label an email as privileged and confidential, does that actually protect it? When small business owners ask me this question, typically they're getting at one of two things. First, they want to know, does adding that label do anything for internal communications to make employees or other email recipients more legally obligated to refrain from disclosing the information to third parties? And second, they're asking, does it mean that legal privilege automatically attaches? There is a huge amount of communication around this, so I want to answer both questions in turn and provide you with some best practices that will help you to actually achieve the results and protections that you're hoping for. But I want to be very clear from the start. Calling something privileged and confidential, or just CCing your lawyer to the message, does not mean that legal privilege will automatically adhere, and documents could still be discoverable in the event of a lawsuit. Philosophically, I have a lot of concerns with the overuse of these confidentiality disclaimers because I think that they give people a false sense of security with no actual legal impact. So let's jump in. What do these privileged and confidential disclaimers actually do, if anything, and how can you ensure that your company's secrets and private information are treated with due discretion? Let's talk about internal and external communications to parties other than your lawyer first. Simply labeling an email as confidential or privileged and confidential does not, on its own, create a legal obligation for employees or other recipients, like your clients or vendors, to refrain from disclosing the information. To effectively protect sensitive information within your company, several best practices should be in place. Employees and others who receive sensitive information should have already signed separate non-disclosure agreements, often referred to as NDAs, or have strict confidentiality and non-disclosure obligations written into their employment contracts or independent contractor contracts, vendor contracts, or whatever other contractual agreements govern your relationship. This is particularly important for high-risk information like trade secrets, financial data, or client lists. These agreements should outline clear responsibilities and potential consequences for breaches. Further, you and your executive team and your external advisors all need to understand and agree that information should be disseminated on a need-to-know basis only. Implement policies and technical safeguards to ensure that confidential or sensitive information is only shared with those who truly need it to perform their jobs. Not all employees require access to all information, so limiting exposure can help minimize risk. Finally, your company should have clear internal policies about handling confidential information. Regular training to remind employees of their obligations regarding confidentiality can also be helpful in reinforcing these policies. While adding a confidential label to an email may signal to recipients that the content is sensitive, it does not, on its own, create a legal safeguard unless it's backed by the proper legal framework, such as an NDA or another contractual agreement. Okay, now let's discuss communications involving your lawyer specifically. And note, these remarks hold true whether the lawyer is your full-time W-2 in-house counsel, a part-time fractional general counsel that you've gauged on a 1099 independent contractor basis, or a lawyer at a traditional law firm that you utilize on an ad hoc and as-needed basis as relevant legal issues arise. In any of those contexts, it is imperative that you understand. Merely labeling a communication as privileged or CCing your attorney on the message does not automatically mean that the attorney-client privilege will attach to it. There are strict conditions that must be met for legal privilege to apply. So for privilege to attach, the communication must be between a client or a prospective client and an attorney, and the purpose of the communication must be to seek or provide legal advice. And even if these conditions are met, privilege can be waived if the communication is shared with third parties outside of that attorney-client relationship. The content of the communication must pertain to legal advice or strategy. Simply CCing a lawyer on a routine business email or using the word privilege does not protect the message if legal advice is not the subject of the communication. Even if an email is marked privileged and confidential, it could still be subject to discovery in the event of a lawsuit if it is determined that the legal privilege does not apply or if privilege has been waived. In discovery, courts will assess the actual content of the communication, not just the label that it carries. Almost every in-house lawyer and fractional general counsel that I've worked with identifies the confusion, overuse, and misuse of the privilege and confidential label by their business partners as a source of distress and concern. Now, as always, you should follow your own lawyer's guidance first and foremost, but here are some best practices to maximize confidentiality and legal privilege that you can discuss with your own independent legal counsel. First, use these labels judiciously. Avoid overusing the privilege and confidential labels. You should use these only when they are genuinely applicable, as overuse can lead to complacency or a false sense of security. Second, document legal discussions clearly. If you want to ensure legal privilege, clearly state that the purpose of the communication is to seek or to provide legal advice. This should be done in the body of the message, not just in the subject line. Third, limit distribution. Privileged communications should only be shared with those directly involved in the legal issue. When you CC a bunch of unnecessary recipients, especially non-lawyers, it could be deemed a waiver of privilege. Fourth, implement confidentiality protocols. Ensure employees understand their legal obligations through written agreements and ongoing training. For especially sensitive topics, have NDAs or specific contractual confidentiality provisions in place. Proper policies and training will also help employees discern whether an issue should be brought to their supervisor or directly to legal counsel, and the appropriate method, be it phone, email, or dropping by an office, to do so. So again, labeling an email as privileged and confidential does not on its own offer legal protection. Legal obligations regarding confidentiality need to be formally established through contracts and policies, and attorney-client privilege requires specific conditions to be met. Draft your emails and choose your recipients accordingly. Business owners, is confidentiality of proprietary information a priority at your company? How do you work with your lawyer to maximize protection?